Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about motions to dismiss in civil litigation. Civil litigation is the court case that happens when one person sues another person for damages or other relief outside of criminal court. So they say, the defendant did something wrong to me and I'm entitled to monetary or other damages, and they ask the court for relief. The document that initiates a civil litigation case is called a complaint. And the complaint lays out all of the allegations that would entitle the plaintiff to relief from the defendant and request the damages that the plaintiff is asking for. And that's what's served upon the defendant by a sheriff or special process server. Once the defendant is served with a complaint and the case is open, they have a limited time period to respond to the complaint, and they can respond in one of two ways. They can either file an answer to the complaint, either admitting or denying the allegations of the complaint and raising any defenses that they have, or they can file something called a motion to dismiss. And a motion to dismiss is a motion asking the court to basically throw the complaint out of court, saying it's improper and dismissing the case without them having to answer the complaint. There's two different bases for a motion to dismiss and two types of motions. One is a 2-6-15 motion that says there's defects on the face of the complaint that make it improper, and the other is a 2-6-19 motion saying that there's some affirmative matter that defeats the complaint. And we'll go over what types of affirmative matters can defeat the complaint. And the 2-6-15 and 2-6-19 motions are named based on the statute, the section of the statute that gives attorneys the power to file them. So I'll talk about a 2-6-15 motion first. A 2-6-15 motion says there's some defect on the face of the complaint. Usually this means that a cause of action hasn't been properly pled. A cause of action is the thing that entitles you to relief. There's elements that for each cause of action that say if these elements are present, then the plaintiff is entitled to damages or some other relief from a defendant. So for example, the elements of a cause of action for negligence are that the defendant had a duty of reasonable care to the plaintiff, the defendant breached that duty. As a result of the breach, the plaintiff was injured, and then pleading some sort of damages that the plaintiff suffered as a result of the defendant's breach. So the complaint has to lay out all of those things and then ask for the damages they're going to ask for. If the complaint fails to do so, the complaint will be dismissed by a 2-6-15 motion if one of those elements are missing. Say they pled that there was a duty and that there was a breach of that duty, but failed to adequately plead that the breach caused the plaintiff's damages. Well, then the defendant's attorney would file this 2-6-15 motion to dismiss and say, well, they didn't plead all the elements of a cause of action, therefore we can't have a whole case when they're not even alleging anything that entitles them to relief, and therefore the complaint should be dismissed. Sometimes the complaint will be dismissed because in Illinois, you're required to plead facts, not just simple allegations. So you can't just say there was a duty, a breach of that duty, causation, and damages. You actually have to lay out what happened in your particular case. What was that breach of duty? What was that duty that they had? And what were the damages? And if you fail to be fact-specific, then that's one basis for dismissing your complaint based on a 2-6-15 motion. A 2-6-19 motion says that there's some affirmative matter that would cause the complaint to be improper and dismissed. So there's actually a list of the types of matters that would cause a complaint to be dismissed in Section 2-6-19 of the statute. And I'm just going to read those off real quick. One is that the court doesn't have jurisdiction to hear the case, so it's being brought in the wrong venue. The plaintiff or the defendant doesn't have the legal capacity to sue or be sued, so they might be a minor, they might be mentally incompetent. There's another lawsuit pending between the same parties based on the same cause of action, so you can't just sue the same person in different courts for the same basis. There's a prior judgment based on the present cause of action that bars this current lawsuit. This is called res judicata. So once you've sued someone and the court's made a decision on your lawsuit on the facts of the case, then you can't sue them again because you didn't like the decision. The lawsuit's barred by the statute of limitations, so every cause of action has a limitations period, and after that time has run, no matter how good your case is, if it's not filed in time, the statute of limitations prevents you from maintaining the cause of action and your case will be dismissed. The claim in question has been previously released, otherwise satisfied, or discharged in bankruptcy. So if I'm claiming you owe me money, and I can just show the receipt where I paid that money, or I've signed a release saying I waive all claims against you, or or the defendant has filed a bankruptcy and discharged the claim, then that can be dismissed through a 2619 motion. The claim is unenforceable under the Statute of Frauds. So the Statute of Frauds is it's a whole different statutory provision that requires certain types of contracts to be in writing. So, and I'm not going to go into detail about what types of contracts those are, but if it is the type of contract that needs to be in writing, and it's not, if it's just an oral contract, then that claim can be thrown out on a motion to dismiss. The claim is unenforceable because the defendant is not an adult or has a disability. So that's similar to the capacity to sue or be sued, but it's a little bit more specific. And then the claim is barred by some other affirmative matter that legally defeats it. So if one of those 9 items happen to be the case, you can file a 2619 motion, and those have to be supported by an affidavit. So you actually have to prove that what you're claiming is true. As far as the claim had been released, you have to attach an affidavit swearing that the claim has been released, and usually attach a copy of the release. And the reason 2619 exists is so that if there's something that makes the case not fair game and it's easily provable, we want to get rid of the case as early as possible in the process so that neither side has to spend a lot on attorney's fees. A release wouldn't be very valuable for a claim if you had to go through an entire trial to prove that the release was signed. So if you have a release from somebody and they try to sue you, you can dispatch with the claim quickly in a 2619 motion. So we've got our 2 different types of motions: the 2615, saying there's defects on the face of the complaint, or the 2619 motion that says that there's some affirmative matter that can cause the claim to be easily dispensed with. And the process for the 2 is similar. Once the motion is filed, there's usually a briefing schedule that's set. So let me back up a little bit. When you file a complaint, you get something called a return date. That's the date that both parties have to appear in court. And when the motion is filed, or when that return date happens, the defendant will usually have their motion on file already, and the court and both parties will set a briefing schedule. What a briefing schedule is basically a timeline where each party gets a chance to file written briefs arguing their side of the motion, and then a hearing date when an oral argument is going to be held. So you set the briefing schedule, and the first brief that is going to be due is from the person filing the motion, the defendant, and that's a memorandum in support of the motion. And that's usually a 15-page document laying out the facts and the law, and basically arguing why they should be successful on the motion. And they usually have about 30 days to file that. 30 days later or so, a response brief is going to be due from the plaintiff. And that's going to be basically a counter brief attacking the arguments that are filed in the defendant's memorandum. And then finally, the defendant or whoever filed the motion is going to get a chance to file a reply brief, which responds to the arguments made by the plaintiff in their response brief. Once all the briefs are submitted to the judge, a hearing is going to be held at which usually evidence isn't presented at this stage. It's just an oral argument where the judge will ask questions of each attorney, and usually each attorney will get a chance to make their case as to why the motion should or should not be granted. After that oral argument, if the motion is granted, depending on the type of motion it is, a couple different things might happen. So if it's a 2619 motion, the case is going to be dismissed, and that's that. There's usually not going to be a chance to replead because it's something that totally and absolutely defeats the claim. So the case is going to be dismissed with prejudice, meaning that there's no opportunity to refile the complaint after amending it. And then the plaintiff can have the opportunity to appeal if they like, or if they don't appeal, the case is over. For a 2615 motion, the one that talks about defects on the face of the complaint, usually what will happen is that the case will be dismissed without prejudice, meaning that the plaintiff will have an opportunity to amend and refile their complaint. So if there's part of a cause of action that's missing, the court wants to get to the facts of the case. They don't like things to be thrown out of court permanently based on procedural defects. So what they'll say is, well, this complaint is defective, but it can be fixed. It can be repaired. So plaintiff, you have 30 days to file an amended complaint fixing the defects in the motion. And then that's what will usually happen is the plaintiff will repair the defects in the complaint, file a new complaint, and then the process will start over. The defendant will either have an opportunity to answer that amended complaint or respond with a motion to dismiss. And it's really not uncommon, especially in a bigger case, to see 3 or 4 amended complaints. After about 4 amended complaints, the court starts to get a little bit upset. But as long as there's forward progress and the complaint is addressing the defects that were argued in the motion to dismiss, the court's usually pretty lenient, because the idea is to try to get past the procedural issues in the case and get to a hearing on the facts of the case. And you don't want people being thrown out of court because there's minor defects in their complaints. So often when we're on the plaintiff side and someone files a motion to dismiss, we'll take a look at the motion and say, well, do they really have a point? Is there a defect here, or is there something worth fighting about? And if there's something that can be easily corrected, whether we think we're going to win the motion or not, then what we'll often do is just, rather than briefing the motion, arguing it, and spending our client's time on that, what we'll do is we'll seek leave of court to just file an amended complaint and cut right to the end result. Because even if we might win on the motion, it's not worth arguing about if the issue can be made moot by filing that amended complaint. Sometimes on a motion to dismiss, it cuts right to the heart of the case, and they're claiming that we don't have standing to bring the cause of action. Our client doesn't actually have the ability to sue the defendant, or a particular cause of action that we're pleading isn't going to apply to the defendant. And that's not as simple as just amending the complaint. So that's when we would brief it and argue it and hope to win on that. So again, to review, when a complaint's filed, you can either file an answer or a 2615 or a 2619 motion to dismiss. 2615 deals with defects on the face of the complaint. 2619 deals with affirmative matters that defeat the claim. After all of the issues in a motion to dismiss have been resolved, if either the complaint has been amended and the defendant doesn't file a new motion to dismiss, the amended complaint, or if the motion to dismiss is defeated, then the court will grant the defendant time to answer the complaint. So the end result is going to be the same as if they had just answered the initial complaint, except some of the issues in between will have been resolved. So if you have any questions, please don't hesitate to call our office at 630-324-6666 to schedule an initial consultation. We have a lot more videos, podcasts, and articles about all sorts of legal topics at learn-about-law.com. And you can also check out my podcast for business owners called seizeyourbusiness.com. Thanks so much for listening.